Hi, I am Elizabeth Diaz, also known as Ross. I am 60 years old and a previous employee of the Liquor Control Board of Ontario, also known as the LCBO. During the past 2 years, I have had an issue with the courts and wish to share the facts of the occurrences, for it is systemic and change is necessary. I have 3 cases and helped a friend with his case. Mine are for pain, anguish, punitive, and tort damages, and my friend's case is for copyright infringement. During our tour in the lower courts, we dealt with condescending judges, who in the end I had reported, and the lawyers who contorted with the judges. On June of 2017, in the lower Hamilton court, I corrected the judge for the final time. No one would allow me to voice the facts, which wasted tax dollars during the process. The judge took out content from the record and then made it impossible to settle our claims in the appeals court. Judges do not adhere to the fact. All that is stated needs to stay on record to facilitate layman's issues. Lawyers and ourselves all heard in the lower court how not once did any judge review the paperwork properly. Even the judge, after reading the paperwork, stated we should be in Toronto. I mentioned he was the first to say so. I had to bully the judge to be heard. Judges also did not read the dollar value, for if they had, we would have been in the Toronto appeals courts years ago. Judges need to state in orders which is the next court to proceed, to facilitate for all, and unfortunately the system is rigged against us. Lawyers contorted, stating to the appeals judges, at Osgoode Hall, I should not have the right to proceed, when they all heard what the Hamilton judge stated. This is outright deceit. For this reason, claims M48023, 25, 26, and 27 need to be overturned, and the opposition for each of these cases for contorting can pay for the files to be copied and expedited to Ottawa. For this was their doing, and penance to me for what they have done. Judges need to adhere and uphold the laws. Note or state to laymen where to proceed and to which court. Laymen can do their own footwork after being advised. My friend's case is for copyrights. His lawyer dropped him and made it impossible to acquire another. The opposition was caught on numerous occasions behind closed doors with judges. Had any layman stolen these rights, they would be charged with grand theft, for the rights are worth a considerable amount of money and ownership and royalties considerably more. Facts have been addressed with all hierarchy management of all pertinent offices that have the right to address and correct the wrongs, and they choose to state they do not have the power. Even after I have found and stated they could, for the laws on their books give them allowance. Who am I speaking of? WSIB, also known as the Workplace Safety Insurance Board, WSIAT, also known as the Workplace Safety Appeals Tribunal, in addition to the LCBO. Even the Ontario Ombudsman's Office and countless more stated they would not investigate after proving they could. The Premier's office made the mistake of giving me the wrong rebuttal, for that office has the power to address and correct WSIB. No different from Ontario Hydro, the head of WSIB is promoted by Queen's Park, and so too can be removed and replaced with someone different and in a lower pay scale. I recommended this in my correspondence. I proved how WSIB and the LCBO 1. Contorted to bury accident reports. 2. Do not educate for an agency went bankrupt after I proved it. 3. Rescript and even bully doctors to change their diagnosis. And 4. Never follow labor laws or the law scripted on their books. The LCBO bullied thousands of us in Ontario to work 7.5-hour shifts with only a 15-minute break for a 3-year period. This led to countless of injuries and all pain, anguish, punitive, and tort damages. They did not anchor shelving units to the walls. C. Do not accommodate per doctor's instructions. D. Would not allow a witness to speak to attest to the facts of how damages occurred. This is admission to guilt. I am speaking of a couple of accidents, and I am seeking out the individuals that were party to one accident in the 90s with myself, where a Christmas helper on his second day of employ had a shelving unit top heavy topple down on him while I had to get him out of harm's way. The other 2 supported the shelving unit from falling completely until we both were safe. I would like these individuals to get a hold of me. This took place at Woodchester Mall, Mississauga. Now, WSIAT, 1, like the rest, also do not follow the laws. 2, do not understand. 1 does not receive severance when one quits their job, only when fired, laid off, or in my case, coerced. And since companies are not to do either when one is injured at work, loss of earnings are a mandate. 3, like my decision, allow for what they want and not what is factual. Example, my hands. I have damages for years, injured reports submitted for years, from 1996 through 1999, and then they say they will only accept the most recent file in the year 2000, when WSIB and the LCBO owe years of arrears for other claims for the same thing. For these reasons, one does not need to appeal. What is required is WSIAT needs to correct their wrongs. And in the end, we need to ensure that WSIAT folds, for we have the WSIB ombudsmen that can do their job without paying tax dollars to support a system that is broken. In past correspondence, I stated, I bully bullies. And since judges, lawyers, and their associates, with their egos, want to call my bluff, I'm now making it public. My past was with the RCMP, and along with the OPP have been copying all facts, and once this is final and able to be corrected, I have asked that a complete investigation be opened for judges, the Canadian Judicial Council, and any other agency that falls in the RCMP and OPP's jurisdiction, and police forces other than these, if necessary, regardless of which province in Canada. No one agency has responded, and since they have 21 business days to do so, their time frame has passed. The police have my authority to start the investigation, for the agencies are contorting and stalling in hopes that this will not proceed. The people have suffered with the courts for 150 years, and now is time for a change. I ask all with complaints against judges, forward them to the appropriate offices, include a copy of the court order, and state the laws that the judge or judges did not adhere to. I also mentioned to Minister Levesque's office how myself and others want to have the referendum rights. Within 2 weeks of this conversation, the Prime Minister-elect Trudeau made mention this would be something in his roster. And since every Commonwealth country has these rights, I believe we have the right as well. This is on a federal and provincial level. Both referendum rights would allow no future errors to occur, such as the Hydro and the Oakville fiasco. We would only have ourselves accountable. Once these rights are scripted, no longer do we need to worry about what party is elected, for they would be accountable to us and finally learn how to govern. Now, Prime Minister Trudeau, I believe he has the best of intentions for the country, just like his father. I state at no time can he or his office be accountable for the heresy they inherited. I ask that you have patience and realize, like his father, time is what he needs to correct wrongs. And this would give him the opportunity to bring us back to a country both of prosperity and pride. I look forward to our future discussions and the opportunity to have these wrongs corrected. I want all of us to collectively get a hold of our incumbents and push for change and have this discussion, maybe on Facebook or any other social media, but push this envelope, push this forward, and let's get this job done. Have a great day.